Welcome, everyone. This is the panel for the rights of access to corporate documentation and the trade secrecy defense, organized by the Institute for Information Law at the University of Amsterdam. My name is Vilma, and I am a PhD candidate studying transparency and confidentiality. And today I am joined by our panelists. So we have Ms. Michaela Gering from the Inquiries Officer and Coordination of the European Ombudswoman. Lisa Stanfield, who is a data protection lawyer at NOIB. Then, unfortunately, Lubisha was not able to be with us today, but we have our wonderful Christina Irion, who is an associate professor at the University of Amsterdam. And last but not least, Danny Mekic, who is also a PhD candidate at the EU Law Center at the University of Leiden, and also is researching human dignity, privacy, and digital technologies. So I would like to start us off with a brief introduction on the panel. So within the EU Digital Rulebook, we do formally have access rights, many access rights, and one of them being, of course, for example, the access to personal data under the GDPR. So we do have ex post transparency mechanisms. However, we see how in practice, these access rights can be restricted, of course, in balancing the interests of others, such as, for example, trade secrets and confidentiality. However, this can oftentimes lead to very protracted legal battles. And this panel will revisit the experiences with trade secrecy claims by providers of digital technologies. What are the responsibilities of regulators? And also, what is the impact of the digital omnibus on transparency rights? And before starting us off, I would like to present a video that we have prepared at the Institute. If that could be played.
There's still chairs in the front. There are still places in the front. Please come forward. It's really nice here.
It's supposed to have audio, but maybe we can skip the video, I guess.
Give it 20 seconds more.
So this is how a lack of transparency sounds.
It's more the sound of suspense, I would say.
They might be
So
close
it's
to each
like
other sometimes.
Well, I guess not. That is okay. We move on then. I would like maybe to ask our panelists now to briefly introduce
recruitment
themselves.
algorithm ranks.
And oh, was that audio? Yeah. Yeah. Okay. To maybe briefly introduce themselves and give us maybe some concrete examples of how you've encountered the topic. So maybe Michaela, if you would like to start.
Yes, thank you, Wilma. And thank you for having me here today. I'm a lawyer and I work as an inquiries officer at the Office of the European Ombudsman. The focus of my work is on public access to documents and transparency. And while I will be speaking in my private capacity here today, I'm happy to share some of the experiences and challenges that the Ombudsman encountered in relation to cases about the disclosure of commercial information. But it's from a public access perspective and will also be beyond a bit the digital sector. The Ombudsman is an independent and impartial body that oversees the EU institutions and agencies to make sure they are transparent, accountable, and ethical. And it also plays a key role in the area of public access to documents because it is one of the two redress mechanisms that can conduct an independent review of a decision by an EU institution to refuse access to documents. When the Ombudsman conducts an inquiry, it can inspect the documents that the EU administration holds, and this includes sensitive and confidential documents, so usually then the documents to which access has been refused. And if the Ombudsman finds that it was not justified, that access was refused, so access should have been granted, she can make recommendations and proposals for solutions to that effect and try and convince the institutions to actually grant wider or full access. The Ombudsman receives complaints in many areas, and also in the area of public access, many complaints about the refusal of access to commercial information. And while there are many exceptions in the public access rules, so Regulation 1049, there are usually two exceptions that the institutions rely on if they refuse access. One of them is the need to protect personal data, and the other one is the need to protect commercial interests of a company. And I'm happy to share some case examples later on. Thank you.
Thank you.
Hello, everyone. Thanks for having me. I'm Lisa. I'm here with Noib. We are digital right enforcement NGO, and what we do is strategic litigation everywhere in Europe to enforce mainly the GDPR and e-privacy. We both represent data subjects and are also a qualified entity to bring collective actions under the Collective Redress Directive. So far, we have almost 900 cases, and we have been confronted a lot with the argument of this is a trade secret or this is a confidential information, and therefore a company would not share it with us or with the supervisory authority. What I find interesting and to keep in mind here is that the question of trade secret and access to documents is a two-layered question. The first layer, I would say, is does the information qualify as a trade secret, which is already a complicated question. And I hope we're going to bring some elements of response to this. And in the affirmative, if it is a trade secret, to what extent it can restrict the right to access of data subjects. And in our practice, we face challenges with both layers, actually. And to finish this round of introduction, I will just give a quick example. For the first layer, so the qualification of certain information as trade secrets, we see controllers or processors, companies in general, that qualify any corporate document as confidential. We had one case where we asked to the controller to give us some corporate documentation about their compliance with the GDPR, and they totally redacted their privacy notice. So this is an attempt to, I don't know if it's to prolong the proceeding or to hide certain things from the data subjects, but so this clearly doesn't qualify as a trade secret because it's a document that is publicly available, right? And we also struggle with controllers that claim that there are trade secrets for the second layer, so how much it can restrict the right to access. And in this case, I would point at the example of credit score agencies. We had cases where we asked them, could you give us access to how you give the score to the data subject? And
thank you, Lisa. Thank you so much. We'll be going more into detail later on into the conversation.
Yes.
I'd like to give the word now to Christina, brief introduction. Thank you.
So hello everyone, I'm leading a research project entitled Artificial Secrecy and Taking Transparency and EU Digital and Data Legislation Seriously. So this panel is part of the research project. I'm not Liu Bija, as you have seen already. Liu Bija is ill, so I'm standing in, but it is a project I'm very, very invested in, because I realize that this is a fundamental tension between the ambition of transparency. Transparency needs also for affected individuals and for public transparency. And on the other hand, the claims of confidentiality and trade secrecy. And it is very interesting from a legal point of view to assess how the law, EU law, strikes a balance between these two different interests. And then there is another factual issue, and that is that because a lot of transactions and processing is happening in corporate or proprietary digital artifacts, it's sometimes not easy to observe what is happening. So that is a huge difference to like observing events in real life, where you can basically see, you can perceive with all your senses what is going on. Whereas in the digital ecosystem, many of these actions are kind of hidden from plain sight. And that makes it sometimes hard to know what has happened. And it also hides, in a way, if something happens that is actually not in line with data protection law, consumer protection law, with anti-discrimination laws, and so many other important protection mechanisms we have in the EU. So you will need, that's what I'm arguing, you will need a certain amount of transparency in order to have actionable evidence, in order to go to other rights and to ensure that companies are aligned with regulatory requirements. And for them, it is very easy, of course, to claim that something is confidential. We heard that already from Lisa before. It is almost, it's free of charge to say this is confidential, this is a trade secret. And to overclaim is also not sanctioned. So we are very interested in looking how in the law we can also deal with this problem of factual secrecy, so that there is a claim made that something is secret, but in fact, it doesn't really meet the standards of the law for such protection. So that raises a lot of procedural issues as well. So today, I'm more researching that as an academic, but we have also people who have real experience with that. So for the introduction, I think that's enough.
Thank you, Christina.
My name is Danny Mekic. I'm a PhD candidate in Leiden and Eindhoven. I'm researching the fundamental right to human dignity as the lower bound of the fundamental rights to privacy and data protection. And during my research, I was encountered with an advertisement campaign derived or sent or bought by the European Commission, and trying to promote the chat control proposal in the countries that were actually not in favor of their legislation. And thanks to transparency requirements arising from the Digital Services Act, I could actually find out that they were not only specifically targeting countries that were not in favor of chat control, but they were also using protected categories of personal data to micro-target these advertisements. I published an article about that, and as a result, I got shadow banned on Twitter. And when I did an access request, which I fought in court in 3 instances, at some point Twitter started slapping me with a gag order request, claiming that my personal data are a trade secret. I'm free to speak today. The requests were overturned. I won all cases. However, I would like to limit any questions and the answers to what has been published as part of the court rulings. But I just want to reiterate that these transparency requirements are very important in democracy, and not only to hold companies to accountability, but our governments and democratic institutions as well.
Thank you very much, Danny. I would like to move us now into a more substantive part, I would say, of the interventions. And Danny, you mentioned that your own personal data was claimed as a trade secret, which is quite absurd. And I would like to ask if within a lot of the internal documentation, part of it is considered confidential, but that is not obviously the case. So if you would like to talk more about your experience with this.
Yeah, so maybe it's good to start with, so we will dive deeper into what a trade secret is. But from a data protection perspective, it's quite interesting because I was not the first one to have this argument in a data subject access request. It was actually Max Schrems when he requested access to his personal data from Facebook. And if you look at the Trade Secrets Directive in recital 40, it is actually referring to an opinion of the European Data Protection Supervisor, which explicitly warned of the risk that data controllers might attempt to restrict access requests by invoking trade secrets. And the European Data Protection Supervisor said that it should not interfere with data subjects' rights, and that there has been at least one well-reported instance of a global company refusing a request from a data subject. And that, well, this reported instance was the Schrems case, and then actually the legislator brought that into recital 35 of the Trade Secret Directive, precisely confirming that trade secrets cannot be invoked to restrict access to personal data. So this is an argument that should not be made in front of courts, because access to personal data cannot be restricted with a trade secret claim. On the other hand, we have seen cases, which we will probably discuss, where other sorts of information under the GDPR were requested as well, such as information regarding algorithms and even complete algorithms as well. But then still, it has been, at least in Austria, a very stable line of jurisprudence that even in these cases, it should not be impossible for data subjects to exercise their rights, and that access must also often be granted. And then also because the definition of trade secret requires substance, given the definition that it should be a body. It's a trade secret as a body or in the precise configuration and assembly of its components. And then the security measures should also be specifically aimed at the trade secret. And then that trade secret should have an independent commercial value. So even if you would argue through that line, personal data of an individual barely have and meet these requirements. So also from that perspective, it's not possible to see them as a trade secret as well. And then lastly, I would like to point out that I think it's a very good move of the Court of Justice that they decided that controllers are required to provide any allegedly protected information to competent supervisory authorities or the court, so that the court is actually able to conduct an assessment of the information and determine whether a trade secret exists at all. And to my quite disappointment, I have not found much jurisprudence where courts are actually analyzing whether the data are or the information are trade secrets. So I think there's room for improvement, because in many cases, I agree with Lisa, in many cases the information might be protected, because the GDPR also requires data controllers to protect personal data, but they do not qualify as trade secrets at all.
Is there maybe, Lisa, anything that you'd like to add? Also in regards to, for example, experiences with the court or with proceedings, any difficulties that you've encountered?
Yes, of course. As I said, we have quite some experience with proceedings and controllers claiming trade secrets. We identify 4 main strategies behind this argument. The first one would be claiming trade secrets to drag the proceeding in time. The second one would be to claim trade secret to actually shift the debate from the violations into a debate on whether the information is trade secret or not. Then the third one would be to for a company to hide insufficient quality of their corporate documents. And here I have an example with a company who was ordered by a court to provide the record of processing activity. So it's one of the main documentation that documents compliance with the GDPR. And they provided a document of 4 pages that was totally insufficient. So it looks like the argument was to avoid providing it. And the fourth strategy, I believe, is particularly relevant in situations of automated decision making. And it's where the companies, they try to hide their documents or their so-called secrets to not reveal how simple their algorithm is. This would be the case for credit scoring agencies, for example, that create scores from very few information and not so much from complex mathematical formulas or complex algorithm. And then they say, oh no, we cannot tell you what it is because it's a secret, but actually it would probably be because it's too simple. Yep.
Thank you very much. So we do see that we have the civil society sort of side and how we have the claims from digital providers side. Maybe on the side of regulators, we could have a little bit more of insight. Michaela, if you could provide with us.
Yes, thank you, Wilma. As I said earlier, the need to protect personal data can also prevent the disclosure of commercial information, because if someone requests access to a document that contains personal data, of course the EU rules on data protection come into play, the EU DPR. Under the EU DPR, personal data, which as you all I'm sure know, is information by which a person can be identified, can be accessed by the public at large only if the applicant establishes that there is a need in the public interest for the disclosure of the information. And while there are other conditions other criteria that have to be met, and this test goes on, this first requirement to establish such a necessity, in my experience, is often already a very difficult hurdle for an applicant seeking access. And this can, of course, be frustrating for someone seeking access, but I think it just reflects the high standard on data protection that we have in the EU. And as a concrete example, we had a case where someone sought access to a clinical study report from the European Medicines Agency, and the EMA had already given wide access to that report about how it was conducted, the findings, even the age and the medical history of the patients who had participated in the clinical trial. But it redacted the pseudonyms used for the patients and their gender because it considered that this was personal data that had to be protected. Now, the applicant considered that this information had to be disclosed so as to enable the public to scrutinize the safety and efficacy of the drug concerned. And while the Ombudsman agreed that this is a very important public interest, she found that the study report could be understood and evaluated based on the information that had been disclosed, and therefore that there was no necessity. However, in cases like this, I think even if there was, someone would manage to establish such a need in the public interest for the disclosure, it's not said that the information would then be disclosed, because, as I said, there's a second part of this test where also the legitimate interests of the data subjects must be considered. And health information is, of course, very sensitive, and therefore I think it is generally difficult. Well, with regards the protection of commercial interests, the law strikes a bit of a different balance, but I think we will come to that later. Yes, thanks.
Thank you very much. And yes, in regards to this balancing, I would say, because we see public interests versus private interests, and maybe Christina, you can walk us through, in your experience, how does this balancing generally happen also inside of the courts?
Thank you. So we figured that corporations are very protective of internal corporate documentation, but that you sometimes need this documentation in order to actually start exercising other rights or your other data protection rights as well. And what we think would be, or what I think would not be sufficient, is that when you get like a cleaned version of the data that the company has, for example, where they basically extract from internal databases and log files the data and present you with an artificially created document that basically holds this information, but it is taken out of the context of the internal data processing documentation. And in fact, the Court of Justice is also quite generous, I would say, what you can request under the right of access from the GDPR. So we know that in the judgment Copier de Dossier Médical, the CGU first of all confirmed that this right of access does not only extend to the data that you have volunteered to a controller, but also concerns derived and inferred data. So also all the data that the company or the data controller has generated about you would be covered by this right of access. And that is then much more than what on the surface is what you have maybe at one point provided. And another important case here from Austria is the CRIF decision from the CGU, where it interprets what you can get as a copy from your personal data under Article 15. And this is quite broad because it says that the copy must reproduce the personal data completely and faithfully so that the data subject can exercise his or her rights under the GDPR. And that includes a copy of extracts from documents or even entire documents or database extracts, among other things. So actually, you can get internal corporate information. And then we have also the Punky judgment, and here the CGU explicitly rules that log files fall under the right of access. So that is the event logging that is often taking place in data-heavy processing activities. And these event loggings are covered also by, or this trail of automated actions in relation to a particular user account would also be covered. And that is only under the general right of access and the right to receive a copy. And then there is also the right of explanation. Also, other speakers have already mentioned it. This right of explanation only applies when there is an automated decision making in the first place. And here, this right is often, it's not absolute, so you don't get, for example, access to the algorithm itself often, but you will get like a narrative that describes in an accessible language how this algorithm, for example, makes decisions, like what you mentioned earlier, credit scoring algorithms, for example. So these are the rights we have, and then at a later stage, the courts will always look if they are, if that would conflict with the rights and freedoms of others. And that is where the trade secret comes in. And the court has developed a certain balancing test here, and we get to that a bit later.
Yes.
Yeah.
Yes, thank you very much. I would like to pick up on something that Lisa said previously, that we don't really know what qualifies as a trade secret, in the sense that we do have perhaps provisions, but then in practice, it's very hard to really see the definition. And so what do you think qualifies, also in your experience in practice, and maybe arguments that have been made, as in this is confidential information or this is our trade secret, but maybe wasn't the case or wasn't such cut clear?
I reply?
Yep.
Okay, so first there is, I think what is really fundamental here is the definition that is in the Trade Secret Directive. It's quite restrictive, and actually it's not so much our position as representative of data subjects to qualify what would be a trade secret. It's more the position of the company itself. And also here, the supervisory authorities have a key role, because under the new procedure regulation and GDPR procedure regulation and the CGU case law, especially Dun & Bradstreet, the controllers, they must provide their information to the supervisory authorities, who will then say if it is trade secret or not. And the procedure regulation is even more specific, because it says, Article 25, that the company has to point at exactly which information would be a trade secret, and also to give a justification. So I would tend to give the floor more to the supervisory authorities, and I expect a lot from this provision.
Yeah, thank you. Is there anyone that maybe would like to add something to this, perhaps?
Yeah, so one interesting argument
Thank
that
you.
I've encountered is that data controls also try to limit the scope of the GDPR by arguing that there should only be the right to access to data that can actually be verified on its lawfulness or not. So but that's going against the literal wordings of recital 63 of the GDPR, which starts with stating that the primary goal of access is actually in order to be aware of the processing. I mean, you need to be aware of a processing before you can actually start analyzing and understanding whether it's lawful and whether the processing is based on correct information or not. Another interesting thing, what I'm sometimes missing in debates about trade secrets, is that trade secrets have a function. it's not a shield against transparency. It's actually a way to protect your business based on what you've been building, investing in, what is really core to what makes you successful as a company. It's not that any information about what you're doing, any document, any line, any piece of information can qualify as a trade secret. And I need to be agreeing with Christina that what's missing here is that it's gratuit to actually make the point of a trade secret, but then there are no consequences if after 1 year of litigation, courts decide, well, there is no trade secret, or there was no reason for doing that. And I feel that's something that we need more research into, especially in relation to the recent judgments of the courts of justice, which also clarified that a violation of Article 15 of the GDPR, so unlawful restriction of access requests, might also lead to damages. So I feel that this is a real new area, especially because the big cases about damages are still to be decided upon on their merits in many of our EU countries. But I feel that it should not, and it cannot be the case that it's a fundamental right to get access to your personal data, and then it gets limited on grounds that then are deemed to be incorrect.
Mm-hmm.
Thank you.
And in addition to trade secrets, we also observe other arguments being raised as part of the confidentiality defense. So the first one is this is a trade secret, so it's super secret to the company, how it operates, and it has commercial value. And the second argument that we see increasingly coming is that divulging this information would undermine the security of the IT system or of the digital service. And then there comes now also a third one that, for example, it would divulge information about how the company works with, for example, advertising partners, and that this would be also so super sensitive that it cannot be disclosed. So it's also within this confidentiality category, there is a layering up. All these arguments are first of all raised. Now, there is the courts and the regulators who have to deal with these arguments. They have to start a balancing. And here I'm seeing that regulators are kind of shying away from really making a draw, like looking at the documents and making an assessment themselves, what should be definitely protected as and kept confidential, and what can be disclosed. They are shying away from it and try to basically avoid being the ones who have to adjudicate the lawfulness of these defenses. Courts cannot shy away. Courts are really doing their job, but they are sometimes not making a clear standpoint that this is not a trade secret. Courts tend to go quite quickly into balancing interests somehow. Yeah, so they are going over this step to first determine if this claim of confidentiality is justified in the first place. So they immediately go in the second. Even if the result is often then in favor of the right of access, I think courts could be a bit more bold and say that is not protected. So you cannot raise this as a protected interest.
And I want to add something really shortly, and this is a reference to Article 25 of the GDPR, which actually forces data controllers to build their systems in such a way that they can facilitate access rights. So even if a claim would be made like, hey, we cannot give this sort of information because our systems, will break down, it's also a violation of the GDPR. But there have not been a lot of cases where this has been determined, and I think we need these cases so that controllers are actually no longer able to hide behind these sorts of argumentations. They need to design systems so that they can actually facilitate access requests.
Mm-hmm.
Yes, thank you very much, Danny.
Yes, I can also say a few words about the public access rules. I think the technical terms are a bit different, but it comes down to in essence, to the same result. So under the access rules, it's not trade secrets that are protected, but generally commercially sensitive information. And the most obvious piece of information that is worthy of protection is actually intellectual property, which is also explicitly mentioned in the rules. But beyond that, like the others already said, is not simply because information relates to a company or its business relations that it makes the information sensitive. Sensitive information is information that, if disclosed, really undermines legitimate commercial interests of the company concerned. So examples from the case law are a business strategy of a company, including its marketing policy, information related to research and development, data related to its suppliers and retail partners, or commercial relations, and of course specific expertise that a company has.
Yes. Thank you very much. And Christina, also you mentioned that the courts could be a bit more clearer when they're taking a standpoint. And in that regard, I would like to ask, when we have procedures, and how do really trade secret claims affect transparency rights? And maybe Danny, if you could guide us more throughout the procedures here.
Yes, I think what Christina just said is correct. So also in my cases, the court didn't assess whether the so-claimed trade secret was actually a trade secret. So it started balancing immediately. And I feel that there is maybe some fear from the courts, because once you actually say, well, this is not a trade secret, you might open the door for everyone in any case. So that might be a larger consequence rather than just judging in a specific case, like, well, in this case, you need to give access to these documentations or to this data or to this information. And that is, I've also been thinking that it's quite hard in an individual case to get some questions to the Court of Justice, which might actually help this sort of high impact cases. And I don't have any solution for that, but and there has been a lot of cases like that where, courts start balancing, even if on a more formal grounds there shouldn't be any balancing, because there is no ground for any limitation to the access right. It's completely true.
Mm-hmm. Yep. Maybe we could get a little bit more into the balancing and how exactly this balancing happens. If there's anyone who'd like to intervene?
Yes.
Yes?
Yeah. I want to say something about the balancing. Usually we balance rights when there is a conflict. And in the case of trade secrets, I think in practice there are not so many occurrences of actual conflicts. Usually the right to access and the right to protect trade secrets, they just coexist, but it's in very few cases that there is an actual trade secret and that it would restrict the right to access. So I would like to take a bit of a bigger picture here and to say that the actual big issue is that there is a huge lack of compliance with the right to access. But let's talk about the balancing in this specific case, of course.
Yes. Is there maybe that, Christina, you would like to add something, or maybe guide us more through also the court?
What I think is
cases.
making it harder to really scale transparency is that each time there is a confidentiality claim, this is basically needs to be adjudicated either by the regulator or the court. And there is no way to say the next time this will not, from that moment on, all these access requests will be complied with afterwards. So what we see is that it leads to a proceduralization, let's say, of transparency. And it also creates like the effect that transparency only comes drip-wise, because everybody has to fight for the transparency and, for example, request that the regulator really does this decision and helps, or go to the court. And by making it so hard, like whenever you want access to corporate documentation, in fact, this also has an effect that creates this artificial secrecy. Yeah. So although we would have access rights, transparency rights that are much further reaching, they are not as actionable as we would like to see it. And that is a problem. Yeah.
And I would like to add that, there is also the elephant in the room, whereas that a lot of companies that we're talking about nowadays are actually based in one of the EU member states, where we have a regulator that's not regulating. And that's a big issue, because that means that all this balancing and the compliance to the law are actually being placed into individual context of individual cases, which obviously might lead in a specific case to that someone might get some transparency, but it will not affect. Usually, it will not affect the behavior of that organization on a bigger scale. And as the European Union, we should really ask ourselves if that's the way we would like to go. There are a lot of talks nowadays about innovation and that we need to give more space to startups, and I think that's completely right. But personally, I think that what we need is not lowering our standards, but actually more incentives to make sure that companies not based in the European Union comply to our standards. Because obviously, if you have rules and then there are these big companies operating from that single EU member state into the whole of Europe and just breaking every rule that they can find, and then you have this little startup here around the corner in Brussels trying to comply with every rule, because otherwise you will get the Belgian authorities on your front door. That's the real issue here. The issue is not the rules. It's that we have a culture of that once you are big enough and can escape into Ireland, to mention the member state I was referring to, you can actually do pretty much what you want. And even if the regulator knocks on the front door, the worst case, you just get, a small bill presented, which you could actually pay in less than a day. So I feel that this is also why we are having this discussion here today, while many, I would say, right holders of transparency rights are facing such an issues, because they are most of the times, they're just standing there alone in front of these big companies, and the governments that we have, including the supervisors, are not helping. And this is a big problem, because it will lead to two groups of organizations operating in the European Union, groups that comply and groups that do not comply. And they might put a split in our societies. And I feel that that's also happening here with the trade seekers, whereas you have transparent EU-based companies operating their systems in a compliant way, facilitating access requests from their customers, versus companies that prefer to do as much as possible to not do that. And that's actually the main issue here. And that's more and more leading to an imbalance in our economy as well, because we put higher standards on our own companies than companies that are being imported from abroad.
Thank you very much, Danny. Thank you. I would like to go back a little bit also to the fact that we do still have the ombudsman, for example, in relation to access, right? So we do still have some control on the regulators in that sense. And maybe, Mikela, I would like to ask because it takes quite some time in practice to get access to a lot of information from regulators. It is quite the lengthy process, and sometimes there's delays over delays. And I would like to ask if perhaps there's been ways to sort of speed up this process in your experience.
Well, speed up the process. I mean, it's clear from the public access rules that really time is of the essence, and that institutions should give or deal with access requests quickly and give access promptly. And that's why we also consider it's very important that there's no delay, and the Ombudsman has developed a fast-track procedure. So if the Ombudsman opens an inquiry into a refusal of access, then normally the documents at issue are inspected within days, and it's also been tried that the first assessment at least is finalized very, very quickly. But in terms of balancing exercises, from my perspective, this is actually can be the solution, because here you have the other way around. You have the EU institutions, the companies, member states that claim that something is commercially sensitive and cannot be disclosed, but then there's always the possibility to argue that there's another public interest that is deemed more important, and therefore, even if there are legitimate commercial interests, that information should be disclosed. And there are a few cases by the court. Just recently, for example, there was a case in front of the Court of Justice where the court found that in terms of harmonized standards, such an overriding public interest exists. Harmonized standards are technical specifications that are drawn up by the European standardization organizations on the request of the European Commission they are published in the OJ, and so essentially they are EU law. And because of that, the court found that in order for the public to familiarize themselves with the rights they have and the obligations they have to comply with, they need access to this information. So documents that had previously had to be purchased now are made public to the public at large by the institutions. Unfortunately, there are not too many court rulings on what actually constitutes an overriding public interest, but there are quite some cases by the Ombudsman where the Ombudsman took a view on this. And one example that we had was about the purchase of face masks during the COVID-19 pandemic by the European Commission. And it's also notable that these face masks, that there were issues with them. They did not meet the required quality. And here the Ombudsman found in general that companies that conduct business with the EU institutions, they should anyhow expect a certain extent of transparency, that certain information on these contracts becomes public. But in this specific case, she also noted that because these millions of masks had been purchased by taxpayers' money, and also in the context of the most serious global health crisis in over a century, and then there had been problems, that there was an overriding public interest and that the public needed to know what steps had been taken to ensure that no faulty masks had been brought into circulation and used. And in this case, the Ombudsman made a recommendation to the Commission, and in reply, the Commission did give wider access, so based on this overriding public interest. Another more recent case example is about an access request about access to a risk assessment report drawn up by a very large online platform, a VLOP, under the Digital Services Act. And in this case, the Ombudsman also took the view that there's a very strong public interest in scrutinizing the compliance of these VLOPs with the obligations under the DSA in light of the very serious fundamental rights violations that can happen on these platforms. So the Ombudsman found that the public has to be able to understand the risks that might be involved in using these the services of these platforms, and also how the companies address and mitigate those risks.
Yes, thank you.
So I would like to come in because what I find concerning is that, as I said earlier, that regulators are trying to shy away from disclosing corporate information they have received as part of a regulatory procedure under the Freedom of Information laws. That is the concept, yeah, that you basically file a FOIA request to a regulator, and that the regulator then has to see if this documentation that comes from a regulated entity can be released under this FOIA request. And we have, for example, seen that under the new rules of procedure of the European Commission, the Commission has adopted for itself these rules where it says that there's a presumption of confidentiality for all documents belonging to proceedings under EU competition law, Digital Markets Act, Digital Services Act, and similar proceedings. Now this is huge because under the higher ranking EU treaties and also the jurisprudence of the Court of Justice, such a massive presumption of confidentiality is not existing. And there is already a case pending by an MEP, I believe. So we are waiting for the decision of the General Court whether these rules of procedure of the Commissions are actually violating EU law. I personally think it's way too broad because it really turns the logic of freedom of information around by giving preference to secrecy. So we will see how that will unpack. But yeah, that's what I wanted to contribute.
Thank you very much. And I would like to now open the floor for some questions. We do have some time. And do we need this maybe? No?
Affiliation. Name?
Yes. And if you could perhaps say your name, please, your affiliation as well, and state your question. Yes.
Hello, thank you very much. My name is Laurie. I'm with Data Rights. Is it me creating this? No. I used to also be a data protection officer dealing with a subject access request. Thank you so much for this panel. I have a question that is tied to shadow ITs, and so it's a mixture of a remark and a question. As a data protection officer, the emerging issue was the use of free tools, but especially by leaders. And so I was really wondering how maybe you would have had experience with also maybe some companies actually using the excuse of corporate secrets, to actually avoid the fact that they barely just realized that they have a huge amount of data, personal data, that they legally have to give back to the individuals, but it's on free tools like WhatsApp and Signal, and they never realized that they're actually absolutely accountable for this as well. Thank you.
Who would like to intervene?
So, just to clarify, you mean that it would be data that the companies would have from WhatsApp or Signal?
Of individuals. It could be employees, but it could be anything. So the reason why I'm asking this is because I used to work in the UK, and in the UK there were more and more rulings where corporations and entities kept on losing because there were subject access requests, and they were like, well, actually we cannot produce this because we don't have a contract with WhatsApp. And the courts were like, well, that's your problem. You have to produce this data. If you're not capable of producing this evidence, we're going to consider that you're hiding evidence, and you're getting sanctioned.
Yes, well, indeed, if a controller that is defining the purposes and means of the processing use a processor, in principle, they should be able to know what is happening, where this data is processed, right? But we face challenges indeed with companies that say, yeah, there are processings that are happening under our responsibility of controllers, but we don't know, we cannot produce anything because the processor is liable for this. In that case, well, I would say it's challenging, and it's a problem between the controller and the processor, and maybe there is someone that claims to be a processor, but that would actually be a controller, and we could go to pursue the rights against them directly.
Thank you. Are there any other questions? Yes, please in the front.
Hello, I'm Clara. I'm a student at Grenoble University and doing an internship at the CNAM. And I would like maybe to hear some remarks, if you have, on the omnibus proposal and the changes it brings to right of access, and especially the abuse of rights topic and the fees maybe controller can charge, and especially in relation with the fact that right of access is sometimes, as said, used to collect evidence.
I would like to answer on the digital omnibus. So the Commission is proposing to change Article 12 of the GDPR to say there are two main changes. The first one would be that the data subjects, they would need a data protection purpose to file an access request. And the second one is that they could abuse their right, basically. And so it would give the controllers more grounds to reject access requests by saying that they are abusive. This is a problem, first because it conflicts with the Charter of Fundamental Rights of the EU, which has an article saying that we have, as data subject, the fundamental right to access. And the Commission didn't really examine how it could undermine the application of a right that we have under the Charter. So legally, it wouldn't work. It also conflicts with the CGU case law that you mentioned earlier. So the digital omnibus would actually be an occasion, maybe a missed occasion in so far, but it's not definitive yet. It would be an occasion to make the right stronger, to make it more enforceable for the data subjects. So this is what we can expect at this point from the negotiations and from the legislature.
And
sorry.
I would like to raise a broader issue here, because more and more often we see proposals coming from the Commission solving non-existing problems and not being accompanied by any analysis of whether the so-proclaimed problems are actually going to be solved by the legislation that they're proposing. So we've seen the same thing with the chat control proposal. Obviously, it's true that in the digital age, people, especially children, are very vulnerable and especially online. But anyone just failed to explain how scanning everyone's personal communications period of everyone 24/7 would actually lead to any more arrests of perpetrators, while the police doesn't have enough capacity to solve the existing cases. For me, I would like to add that this omnibus proposal, it's fundamentally flawed, because there was not any analysis of whether there is any real life existing issue. And before doing that, you cannot make any legislation because you're not able to actually test whether that legislation is going to solve the things you would like to solve.
Mm-hmm. And if I may add here, is that the GDPR right of access is, from the whole digital rulebook of the EU, the only data or the only right that individuals have to really meaningfully get information from corporations and also public authorities. And therefore, this is a gateway to also enforcing rights under the AI Act, under the DMA, the DSA, and so on. So if now these digital omnibus amendments would be accepted, it would be cut back to only being usable in the context of the GDPR, no longer becoming or could be no longer the stepping stone to also make complaints under anti-discrimination laws, for example, or outside of the field of data protection. And that would be a really, really massive cutting back on what individuals can really do themselves.
Thank you. Any other questions? Yeah, here.
Hello, thank you so much for this interesting panel. My name is Manan, I'm from Leiden University. My question's for Michaela. You mentioned why public access to data is important for risk regulation under the DSA, and I strongly agree with your opinion. But what I want to understand is that in a lot of instances, it's a little difficult for platforms to be able to provide information on the kind of risks and harms that they're posing to users. And a lot of instances, digital services can be used by malicious actors, and unintended consequences can arise from that. And also like causality on like platform from like service to risk or service to harm is also difficult. So I just want to understand in your point of view, what can be like a solution to something like this? How can we ensure transparency where platforms themselves aren't fully aware of the risks and harms online?
Well, I would like to emphasize it's really the VLOBs, the very large online platforms, that have this obligation of reporting once a year, actually, to the Commission about the risks on their platform. So I think, they should be aware because they're looking into this regularly. And there's also every year then an independent audit that looks into this. And then on top of it, the Commission comes into play. They enforce the DSA. So they will then check whether all risks have been properly identified, addressed, mitigated, and all of this. And this is what this report that I talked about is about. I mean, this is the risk assessment, and actually is a document that is meant to become public as well at some point. So the VLOB itself, they have to publish it, not right away when they send it on to the Commission, but 3 months, I believe, after the audit report has also been finalized, this has to become public. But yeah, the problem here was also that they can then, the companies, they can redact what they consider commercially sensitive. So while this report during the inquiry has become public, it was redacted. And yeah, then the goal was a bit to get the Commission to look into it, also from a public access perspective. But as Christina pointed out, the Commission used the general presumption of non-disclosure here. And maybe on this, I would also like to say that, I mean, irrespective of whether this was reasonable or not, this is always an option. And yeah, I would hope the institutions would opt more often for the possibility to actually assess documents, also for the sake of building trust and public perception. Hope this addresses your question.
Thank you. We have another question. So
Three more,
first
yeah.
or 3 more, yes. And then in the front.
Hello, Andreas Heuselmann, Assistant Professor of Privacy Data Protection Law at the Open Universiteit. And so during the panel, we actually pointed to the difficulty that there is this balancing exercise with regard to trade secrets and the right of access. So my question is, shouldn't we perhaps flip the coin and actually start restricting the trade secrets protection? If we look at the Trade Secrets Directive, actually under Article 5, there are already some derogations or exceptions. So my question is, wouldn't it be maybe more efficient to also mention the right of access under the Trade Secrets Directive, at least when it comes to obtain a copy of your personal data?
Who would like to take this one? Christina?
So thank you for your question. What I think about that is that currently we have already in the Trade Secret Directive this recital that says that trade secrets should not be used to restrict unduly the right of access under data protection law. So in a way, this indication of the legislative intent is there. And the Trade Secret Directive also only applies in the context of civil procedures. Yeah, it's not something, the Trade Secret Directive, would not be applied by regulators or the European Commission when they are assessing whether something is confidential. They are using more a broader confidentiality assessment, I believe. Yeah, trade secret is not part of the directive and the definition of it.
No, it's not mentioned.
Exactly. And the definition in itself, that is also what Danny earlier said, is already pretty, it's not too broad. It is very well defined. What is the problem is that it is too easy to claim, and then you first have to get through this procedural step to bring it like balance and send it out. So I'm not sure that would help. What I think would help is, for example, strengthening rules, like clarifying more what is an overriding public interest for journalists, critical engineers, NGOs, anti-discrimination bodies, human rights organizations, and so on. I think there should be a mechanism where you can request public audits, and instead of just waiting for regulators to enforce.
Thank you. There were some questions in the front. I think there.
Hi, I'm Alet Horjes. I work for KPMG. I have a question that is kind of an adjacent topic to this. So the Digital Services Act in Article 40 contains a data access procedure for vetted researchers. It's starting to model also with the Delegated Act how VLOPs should provide access to vetted researchers to certain types of data that is mostly public, but it can also be non-public data. I'm curious to hear your thoughts on this, and also whether that process or that obligation within the DSA and the Delegated Act can be used to improve the rights of access of data protection requests by data subjects.
Yes, would like to reply?
I'm not a DSA expert. I would say we have the Digital Service Observatory in the Institute who is doing the DSA work, and I'm looking at my colleague now, but okay, I'm having the mic, so I have to say something. The DSA Article 40, researcher data access, is actually, it's a really cool thing to have, but it is also very small. It is actually limited to doing research on systemic rights, so systemic risks. So you cannot do research that is not related to systemic risk, and maybe consumer protection doesn't exactly qualify as a systemic risk. So that's one thing. The other thing is that it is limited to vetted researchers. so it's more academic research oriented. It's not what I'm envisaging for this public interest research that is broader, that also should be given to NGOs and journalists, for example. But it is maybe a beginning of something happening here. And it is, of course, limited to VLOPs and the DSA. So it's not something that you can use in the context of other EU digital legislation. So let's say it is like as if a sun ray breaks through clouds, right? Like there is something, but it is not enough to make it a beach day. Yeah.
Yeah, thank you. Yeah, one last question here.
So, Levan from Noib, this was not scripted, I swear. And my question is about something that Lisa mentioned, but the question is actually to Danny. So often companies use the trade secrets arguments to delay or not comply with the access request. And Danny, correct me if I'm wrong, but in the Court of Appeals actually said in your case that they would review the data themselves and decide if they actually contain trade secrets or not. Is that correct?
Yes, so X was ordered to hand over all information that according to X is confidential or should be kept confidential, and then after that the court reviewed that information.
Yes, and so my question is, how did you find that process? Was it good enough in this case? Did it actually help them delay it well enough? Could there be a solution of some sorts? What is your opinion? How did that go?
Yeah, I mean, it was very interesting because you start arguing something that you don't know. So you just get an empty sheet. Like I got 100 pages completely redacted, so I had no idea what I was talking about. On the other hand, I felt so it strengthened my trust in the court system, because I remember that we had an interim hearing and the judges said, well, also in front of all public that was there, we have a really huge duty to actually review this information, because we are actually now limiting one of the participants' rights to have a fair trial to some extent, because normally you should be able to respond to all the arguments that the other party is actually bringing in. So I mean, it was, you need to have trust in the system. On the other hand, I'm talking about delays. I'm thinking about this topic a lot because the case lasted and took a while. And I think that it would not be a bad idea, but I'm not there yet that I can describe how I would implement it. But I feel that maybe that information had to be submitted earlier. So right now it was just at some point a time in the procedure that actually the court ordered that information. And maybe it would not be a bad idea to instigate a rule where you say, well, listen, if you're a data controller and you want to exclude any information from the access request, you need to proactively submit that to the court, or you need to somehow box it in advance, so that but on the other hand, I also believe that you should still have the right to object this sort of proceedings, because maybe in some cases you don't want the court actually to have access to that confidential information. So it's a very complex topic, but you need to have trust in the court system, and I think we have great judges in the European Union, and in this case, it worked out well.
Thank you. Yes, Lisa?
Yeah, I just want to add, of course, you need to have trust in the court systems, but the matters that are submitted to courts are very much small numbers compared to the large numbers of access requests that are not replied to, or that are incompletely replied to, or the argument of trade secret is used. So yes, courts have a role, but not everyone has the resources and capacity to go to court. So the aim of this regulation is to apply also outside of court.
Thank you. Are there any other questions? Yes, here in the front.
Thank you so much. Thank you for the very interesting panel. I will try to keep myself short. I'm Isabella. I'm a researcher at CTIP in KU11, and I'm very interested in the idea perfect of public interest and access to information. So I've been researching a lot about this idea of audits as well, and I see them as an interesting remedy that has been put in place for also allowing for more access to information. But I always wonder a bit about how this is placed on the context of freedom of information without intervention of the state, because there is this part of the fundamental right. And also how we can leverage the right of access to information when we are talking about social representation, so group representation, and this idea of also group personal data protection. Thank you so much.
Thank you. Who would like to answer? No one.
So thank you for your question, Isabel. We have clearly a bifurcation between the right of access when you turn towards public authorities, which are government bodies, are also, of course, under an obligation and to adhere to fundamental rights, right? I cannot go to a tech company and say my my fundamental right of a fair procedure or of a fair trial is affected, because this is in the private relationship not directly applying. So you always need then to go through a law that gives you these rights. So it is a bit different in which context you are moving, right? So the collective part, and that is an interesting idea. I also believe that there's a lot of potential, because at the moment we are putting all our hopes on regulators, and regulators have two problems. On the one hand, they are limited in their resources and capabilities, and I don't know who of you has already filed a complaint to a regulator, but often I get this complaint back with the nice sentence that this is not part of our priorities right now, or that they are beyond capacity and they cannot follow up each complaint from the public. And that was it. So when we place our hopes on regulators, then this is going to be not good enough. So that is why don't we work with societal partners that have proven over the past to be very effective, but then we need to enable them, and that is exactly where this overriding public interest should kick in. But we are having at the moment not enough case law and not enough strong language, let's say, in these regulations to make them become serious stakeholders. And of course, this is also not something that industry would want, right?
Thank you. I think, yes, that was it. We're 1 minute early, actually. But thank you so much for the panelists for joining us today, and thank you also to the audience.